morning, good afternoon, and good evening to the participants today. And yes, we had a very interesting and lively conversation this morning. As Camille has said, the role of corporate secretary really has evolved. And there was, one time in the past where it was considered just an administrative role. But there have been so many changes that have taken place and significant amendments in terms of the responsibility of the corporate secretary. And along with those amendments have been changes in the obligations and the liabilities that a corporate secretary is faced with. Because of various amendments to anti-money laundering and FACTA, the Financial Action Task Force, there have been very onerous responsibilities placed on regulatory compliance. And with that, there have been changes on the obligations and liabilities. So just to touch on a few of them briefly, one of the obligations that the corporate secretary has is the regulatory annual filings, the various notices and whatnot. Now, in Trinidad and Tobago, we've had various amnesties in place, and a lot of companies have not complied. When those amnesties come to an end, the companies that have not filed, there is a penalty, a monetary penalty, 300, it's TT dollars, because I'm speaking about Trinidad and Tobago, for every month that you haven't complied. Now, we have companies that have gone back to, the last major amendment was 2019. And we have companies that go back long before that. And especially companies where, say, for example, it's a townhouse complex and there's a management company. Many of these management companies do not comply. And there's a liability which would be attached to the corporate secretary for these filings, or penalties that haven't been paid. So that's one area where liability of the corporate secretary has imposed itself. But building on from that, in addition to annual compliance, there's what we call beneficial ownership compliance, which was introduced in 2019 into our legislation here. And that requires that every year a company will take steps to ascertain who the ultimate beneficial owners are of a company. This does not just involve the company in question that is registered, but it involves all of the shareholders and the shareholders of the immediate shareholder going all the way up the chain. And non-compliance faces a fine of $10,000 and imprisonment for 3 years. Now, this is an annual obligation. So a company secretary in a scenario where there are of a large corporation, for example, where they're managing more than one company, it's quite onerous in terms of ensuring there's compliance, ensuring everything fits together. And the liability increases every year for non-compliance. So it's quite a lot to have to manage. Now, in addition to that, there are all of the records of the company that have to be filed and kept in order. And again, that carries a penalty of also $10,000 and imprisonment. So as an officer of the company, the corporate secretary has a lot of juggling to do in sitting in at various board meetings. Any changes that are taking place has to be on the ball and has to understand for a commercial decision that may have been taken. Oh, we're changing out this shareholder, somebody is buying in, we're selling. They have to know, well, oh, this means that there's going to be a change in the ultimate beneficial owner. So now I have to file these documents. I have to file the relevant returns to show that there has been a change. And then annually, I must file the documentation to illustrate that there's now a new beneficial owner. And a slip in that in a period where there is no amnesty could result in liability for a corporate secretary. So they have to be very aware of the liability and the requirements. Now, the corporate secretary, as an officer of the company, has various fiduciary duties. And we spoke this morning on the tension that sometimes exists between corporate secretary and general counsel. But that is where knowing the importance of what has to be filed and understanding your fiduciary duty to, act honestly and in good faith, even in the face of a commercial decision, which may want the company to go in a certain direction. You have to stand your ground there, because if you don't, there are serious liabilities and implications that hold for a company secretary. Another one of those, I should say, in terms of maintaining the company records. For example, because of COVID, a lot of companies moved away from having in-person meetings to having virtual meetings, annual general meetings, and that sort of meeting. If the bylaws or the articles of a company did not support having virtual meetings, one of the roles of the corporate secretary will be to say, hold on a minute, before we have a virtual meeting, we need to amend the articles, or we need to amend the bylaws in a case like this to cater for having such a meeting. Proceeding to have meetings without making the necessary amendments means that a corporate secretary, hasn't maintained the company records, and that imposes a liability. So it really means being on top of all of the records and the ambit of authority, and making sure that those changes have taken place. Otherwise, as an officer of the company, you are incurring, or you can incur, liability, monetary, and potentially, if there's summary conviction, imprisonment. Now, the regulatory body in Trinidad and Tobago, as Camille said, is the company's registry, because the legislation is placed in our Company Act, which was the act that was amended. And so being on top of the company registry, the company law, is very important in terms of understanding your role and what the potential liability is. But the registry previously may have been quite quiet in terms of enforcement. But at the moment, they're not, because of the legislation and because of the international, anti-money laundering. And in order to demonstrate and to force companies to comply, they've now been very active. So the prospect of there being some sort of summary conviction, because they come and they start to audit companies, is very real. So company secretaries cannot be complacent. They must be on top of the regulatory position, and they must understand that accepting a role as a corporate secretary of any organization is not just an administrative role. It goes way more than that, and it has potentially far-reaching exposure for you in terms of liability, financial and otherwise. So that sort of sets the framework of what the position is in Trinidad. I know that my other fellow panelists may have different positions in terms of their jurisdictions, but that's the sort of lay of the land, as it were, in Trinidad.
Debra, we could not have asked for a better opening batsman at this wicket. You are pointing out to us that we can go to jail. That is terrifying. I mean, not to mention our poor little house and car that we have, and we have to go sell them to go pay fines. No, girl, you joking here. And that's the whole point, that when we're talking about legal general counsel versus company secretary, and the company secretary position needs to understand laws, but they don't have to be general counsel, because as company secretary, we have our own set of problems we have to deal with. Debra just told us all about them. So at this point in time, I'm going to go over to Terry Peterson in St. Maarten. Terry, is it the same there for you? Terry is a corporate services professional of over 15 years experience in commercial and corporate banking. He holds an LLM in international law and human rights law from Coventry University in the UK, and has authored human rights articles in various publications. He formerly served as advisor on the Corporate Governance Council of the Government of St. Maarten, and has successfully completed several corporate governance and risk management programs. Terry, we invite you to share with us your perspective on this issue of the liabilities of the corporate secretary.
Yes, thank you very much for this introduction, and also congratulations to my fellow distinguished panelists. I'm extremely glad to be able to share, and thank you for the invitation, Camille, and the Caribbean Corporate Governance Institute for allowing me to share from my jurisdiction in the Dutch Caribbean at the moment. I've had the opportunity, as you heard, to serve as an advisor on the Corporate Governance Council of St. Maarten, as well as the corporate secretary for that institution. They're able to advise on dividend policy, the acquisition and disposal of shares, as well as the removal of the supervisory boards for government-owned companies and the managing boards for government-owned companies. So what I'm going to do is I'm just going to talk about a little bit about this entity. Why? Because the articles of incorporation, as we know it, is what forms the framework for corporate governance for these entities. However, because they do not have articles of incorporation, they depend on the national ordinance. They are what they call ZBOs or ZBOs in the Netherlands Antilles, as well as in Holland. And they are supposed to be self-standing and independent bodies. Now, this entity makes no distinction between the categories of corporate officers and corporate secretaries, because there is no distinction really in the Dutch Civil Code. So it is not always clear, except that the book 2 of the Netherlands Antilles Code refers to associations, foundations, as well as private and public liability companies. So this in other words, may not be applicable to institutions that are not incorporated. The second thing that I want to touch about is whether there is liability for the corporate secretary in that kind of institution. That is very difficult to establish based on what I've said before. And so now we go over to the private liability companies. Of course, we have the articles of incorporation, and we have the national ordinance, and we also have the acts of government. And these associations, of course, the Dutch law stipulates that these entities must have articles of incorporation. And because of the articles of incorporation, this is where the companies will get their guidance. And again, the articles of incorporation refers to directors, management, and supervisory directors. It does not specifically state anything about a corporate secretary. So corporate secretary in the Dutch jurisdiction is something that is developing over time. And as it develops and evolves, usually a corporate secretary would be someone who was an administrator or part of the supervisory board or part of the management board. What we see in the new trends now is that most of those NVs or incorporated entities are now seeking legal firms to act as corporate secretaries. Why? Because as the role evolves and it grows, there becomes more liability, or people become more culpable. They realize that they need more legal advice. So they're now turning, in a way to insulate themselves, they're turning to external law firms to expand, to be able to deal with the expanding role of the corporate secretary. The other thing is, I've noticed is that insurance companies now are providing liability insurances to cover corporate officers because of the possibility of personal liability. And liability raises the question of whether there would be insurance to cover an individual. Usually, the same person who deals with compliance within the firm would have been the corporate secretary. But as we know, the bedrock of criminal liability is mens rea. The existence of a claim on a corporation does not in itself incur liability for the officers of the company. But in Dutch law, it would have to be proven that there was a tortious act or there was personal wrongdoing taking place. Now, there is something else that I've noticed as well in terms of responsible corporate officers doctrine, where an officer in an entity does not have to be involved or even aware of what is happening, but by virtue of their status and their position in the company as a responsible officer, the courts would tend to look at this as being sufficient participation and personal involvement. And thereby, this responsible corporate officer doctrine would impute liability on the individual or attach personal responsibility to an individual. The other thing that is happening now more often than before is that we see a lot of amending of articles of incorporations because of the regulatory pressure and the court decisions that are taking place. Articles of incorporations are being amended. From the organization that I sat on, they're now changing from an advisory body to a foundation with a two-tier structure, a supervisory board and a managing board. And they will also include a compliance officer or corporate secretary. Not only that, not only the change of the entity or the structure, but they're also looking at the articles of incorporation. I don't know if you're aware of the Mylan's pharmaceutical case in the US in 2014, where through a process called inversion, the CEO of that company moved the company to the Netherlands and changed the organization from what it was in the US to a stichting, something called a stichting or a foundation in the Netherlands. And through that process, she was able to save a company from a hostile takeover as well as escape personal liability. That's the Mylan pharmaceutical case. And that was in 2014. I will drop the link on a video for persons to watch later that they can watch in their own time, about how the ending of structures to be able to insulate oneself from personal liability. I will pause now to allow another contributor to share more about the authority and ambit of personal responsibilities.
Terry, thank you so much for your contribution. And I think what is coming out are some of the differences between your civil law jurisdiction and our common law jurisdictions, where our companies are required to have company secretaries. But certainly this whole point about, the need for insurance and the potential liabilities, it seems that is common across our jurisdictions. So thank you so much for that, Terry. And just to mention to persons that there is a storm headed to St. Maarten. So that is what is causing some of the disruption in Terry's internet. So Terry, thank you so much for taking the time to be with us, and I hope you can stay through the end. And Terry has agreed he's going to keep that storm from becoming a hurricane. So we are all clear about our roles here today. Moving on now to Sharalee Gittens. Sharalee is the Senior Manager, Legal and Corporate Secretary for Scotiabank, Barbados. She is an attorney at law, qualified to practice law in Barbados, England, and Wales, multi-jurisdictional. She's currently the General Counsel and Corporate Secretary for the Scotiabank Barbados Group and was previously a Senior Associate in a leading corporate commercial legal practice in Barbados. She has over 10 years of experience spanning a variety of legal areas. So Sharalee, welcome to our podium and share with us your bountiful knowledge.
Thank you so much, Camille, and thanks as well, Camille, for inviting me to be a part of this panel. So I'm going to change things up a little bit. I know Debra would have given a great introduction on the liability of a corporate secretary generally under our company's legislation, but I'm going to bring, the majority of us are used to corporate secretaries being an in-house role, but I'm going to bring a bit of a dual side to that because I have also acted for a third-party provider where, the firm that I was with did have a corporate services entity, and the attorneys in the firm did act as authorized representatives of that and acted as corporate secretary for companies. So I'm going to look at both of those angles. Another thing that I want to also touch on is the fact that your liability as a corporate secretary varies according to the type of entity that you are providing that service to. So from the point of view of a country like Barbados, I know we have people here from the Bahamas, from the Cayman Islands, various different jurisdictions within the Caribbean and even across the globe where your country is an offshore financial services center. And because of that, because of the continuing and increasing regulation, I know Camille mentioned it earlier and in the panels before, this increasing focus on governance, and that has informed the type of obligations that companies have to fall under by virtue of there being banks and mutual funds and insurance companies. Regular companies have been dragged along and have a higher standard of the type of governance that they need to comply with. And that has obviously then changed the type of responsibilities that the corporate secretary has. So from Barbados, and I think the same would stand for many common law jurisdictions, you have various sources of what your liability as a corporate secretary are. So that will either come from the company's law, so the statutes, the company's law statutes. If you are acting for a company that, say for example, is a bank like myself, or you have insurance companies, we have insurance companies in our group, we have different regulated entities, and you will find that the legislation governing those entities will impose additional obligations on the role of the secretary as a senior officer. You also have your own internal obligations, whether it's in the case of a third-party corporate services provider where you have a contractual obligation with your with the company that you act as corporate secretary for, or if you are the employed corporate secretary, you have both employment law obligations and liabilities, as well as those liabilities directly to the board of directors. So you always have to pay all of those in mind. You have to pay attention to those. You have to distinguish where there is some overlap between your contractual obligations as well as any statutory obligations, any regulatory obligations. We know there are a multitude of even international regulations that change the type of liability you have. For example, with with various international banks, insurance companies, where you have a shareholder that may be outside of the jurisdiction. You may have your shareholders in the UK, your shareholders in the US or Canada. You also have to be aware that you're carrying out your duty as corporate secretary for a subsidiary of an entity regulated in another country, that imposes additional obligations on you because you do have an obligation to the company, and that company has an obligation to its shareholder company or shareholder group. So when we think about those, and we think about the fact that a corporate secretary is a senior officer and is treated by many regulators as a senior officer, that changes, you know, the experience. And Camille, you talked about the common law and how even the common law has evolved and seen the move from just an administrative type role, but being very involved in governance, very involved in giving instruction. In the panel before, you know, we talked about the fact that sometimes you can have competing interests with the general counsel role and the company's or management's view. So that is something that, you know, I think is paramount. You know, primary duty will always be to the company. Your obligation or your liability is to the company. Your obligation is to ensure that the company is satisfying its company's law obligations, its regulatory obligations. Debra would have gone through quite a few of those, and, you know, warned us and reminded us that you can't be personally liable because it is a fiduciary duty. One of the other things that I wanted to mention as well is, you know, we don't always think about it in this way, but as a corporate secretary, in many instances, you are going to be a signing officer of the company. So whether that's going to be just for contracts, whether that's going to be on the bank accounts, whether that's going to be some other way, you know, based on the bylaws where you have the capacity as a senior officer to bind the company, it gives an extra layer of responsibility for you, because you do have that liability now that if you sign something that does not fall within the ambit of the bylaws of the company, the articles of the company, any internal policies, then you expose yourself, because you will be acting out of line of what the company has set in place. You know, Terry mentioned liability insurance, and I know depending on the organization, you may not have a group liability insurance policy. So you also have to be aware that if you are seen as doing something or taking an action that doesn't fall within the parameters of what your duties and obligations are within the context of your employment or the context of your engagement as a corporate secretary, you may also be seen as acting outside of that role, and do expose yourself to some sort of personal liability that will not be covered by your company or your client's limited liability insurance. So those are some of the things you know, that we need to be aware of as well. One final thing that I will touch on, and Debra mentioned it as well, is with respect to your liability as a record keeper of the company. You know, in many cases, whether you are an in-house corporate secretary, an external corporate secretary, you will likely be the holder of the records. You're going to be the person responsible for ensuring that the minutes are signed and that they are on the binder or the minute books of the company, that any written resolutions are there, you know, the incorporation documents are there. You have to follow up and make sure that any filings that you did, whether it's with the company's registry or the regulators, you know, do you have copies of what was submitted? Did you follow up and get the registered versions back? Because at any point in time, which with most jurisdictions now, your tax authorities can knock on the door anytime and ask for copies. Your regulator can knock on the door and ask for copies. Even your shareholders and your directors can ask for copies. And if you don't do a diligent job of keeping those records up to date in your role as the record keeper, then that's an additional set of liability that you expose yourself to. So that is my 25 cents for today. And I'll pass it back over to Camille, as I think we will probably go into questions.
Sharalee, thank you for that. And that was a mouthful. And she mentioned so many important areas. Signing officer of the company. That is such a critical role. The keeping of the seal, the custody of the seal, so as to ensure that it is not used in an unauthorized way. So when one of these banks that will remain nameless sends over some document and says, affix the seal to wherever and no seal and there was no resolution and you don't have the knowledge and you are just affixing your seal all over the place and there is no record of it. No, no, no. You need to have enough knowledge to understand on what basis and how that seal is to be used and the record that has to be kept of it, and the fact that you need to go and get a board resolution, not just affix a seal. And that takes us to things like delegation of authority, which Sharalee mentioned. You have to ensure that everybody is acting within the scope of their authority. Then she spoke about being the holder of the records. So here we are all having these online meetings that our articles don't allow us to do, as Debra pointed out. And there we go now, we do up these minutes that are never signed because nobody is coming into the office to sign the minutes. And then somebody comes to read these unsigned minutes. Are you liable? And then we keep talking about needing to merge these two roles, and understand I've always done the merge two roles, but the role of the company secretary has so evolved and there are so many responsibilities, not to mention when Sharalee started talking about tax authorities coming to review. Ladies and gentlemen, we have gone through a wide range of issues and a wide range of responsibilities and a wide range of areas where the company secretary can be liable. So Debra, do you want to respond to anything you heard from Terry or Sharalee?
I do agree entirely with what Sharalee said. You know, the implications are far-reaching if you are an actual service provider yourself to, you know, companies that have corporate secretarial services. You really do have to make sure that all your I's are dotted and your T's are crossed, because you have your on top of the liability that you have the regulatory liability, you then have the contractual liability. And that could have even more far-reaching effects than the monetary fines, you know, in terms of the consequences basically of your non-compliance to the company itself. So it really is quite onerous, and it's a role that really has to be taken very seriously. Terry, I noticed the position in St. Maarten. I mean, it really is quite different to what we have in Trinidad, and I suspect Barbados is sort of falls along the lines of Trinidad as well. It's very interesting and different, but again, it doesn't change the obligations and the responsibility that is placed in terms of liability on a provider of corporate secretarial services. All to say that this is not a role that can be trivialized at all. And yes, Camille, as you said, it's your baby bathwater that could go out as well if you don't pay attention to the responsibilities. I agree completely with what you said there. So yes, it's a role that has been expanding and is going to expand even more, as will the liability for non-compliance. So it's something that we have to take very seriously. And I think more and more of these presentations where we focus on this are absolutely necessary.
Yes, Debra, I agree with you on that, because so many persons, we get into these roles and we are not really aware of the potential liabilities. And that's really dangerous. That's really dangerous. So I think, Camille, we have a big job to do at CCGI in making sure persons understand the role of the corporate secretary, what is required, and what the liabilities could be. Terry, did you want to weigh in on anything you heard from Sharalee?
Yes, I was just thinking in terms of a case that was ongoing where a lawyer, an independent lawyer, was selected to act as corporate secretary for a government-owned company. And in the process of serving that role, some changes were taking place with the supervisory board. The supervisory board collapsed, and the lawyer in turn became chairman, advisor, and corporate secretary all at once. And it was a very difficult position for him to be in, assuming all those roles without proper resolutions, as were mentioned before. There was nothing on paper to show, okay, an action was taken by by a supervisory board, assigning him these various roles. And he was the mouthpiece for the company, out in the public and papers, speaking on behalf of the company. And that created quite a stir in terms of corporate governance. So I think there are lots of areas in the role of the corporate secretary that's not very clear to the wider public, as well as to the persons who are being selected to serve on those companies. For government-owned companies, mostly you know that persons are selected because they are politically appointed, and not because that they have the training and they have the capability to serve as a corporate secretary. They are not often thinking about that they could become personally liable for some of the actions that are taken if it can be proven that there is sufficient participation or personal involvement. While the trend is for the courts to go after the CEOs and the directors, more and more now the courts are looking closely at other corporate officers in the companies and seeing how they are performing and what is happening with the company. And because we are using ancient codes and using ancient laws that have been amended, and now we would have to find a way to define what it is the role of the corporate secretary is.
Yeah, thank you for that, Terry. And you mentioned what is happening in the public sector. So we should pay a little attention to the public sector. And certainly here in Jamaica, we have had regulations passed in December last year, was it? And those regulations now stipulate very clearly, they under our public PBMA, Public Bodies Management and Accountability Act, we now have regulations regarding the selection and nomination of directors. So the directors who are appointed to public sector boards in Jamaica are required now to fulfill the competency requirements of that board. So it can't just be that you're a friend of a minister. You actually have to have the competencies that have been designated as needed for that board. And as we said in our Companies Act, and also in our, I don't think the PBMA specifically mentions it, but our Companies Act in Jamaica, similar to Trinidad, and I think Barbados is probably the same. We tend to be more or less similar. The law states that the company secretary has to have the required experience and qualifications for the job. Doesn't say what those qualifications have to be. Doesn't have to be a lawyer, but you have to have the requisite qualifications. And that's important because, as we said, it is so unfair to put somebody in this role who does not understand what is needed, because you don't even know what you don't know. And so it really is quite dangerous. Now, members, please feel free to put your questions in the chat or to raise your hand, and if we can see, turn off your mic like I do when my chat thing is not listening to me, my reaction thing, and share with us your experiences. But going back also to what we spoke about earlier, I think when you are general counsel, that corporate secretary can be your biggest ally. As I mentioned before, sometimes when you are GC, you are so caught up in those legal issues that the procedural side, perhaps, which is going along more quietly, but which is a potential bomb, could escape your immediate attention. So when you have that corporate secretary or that good support unit to you as a general counsel and corporate secretary, if you have that combined role, they can say to you, remember this filing, remember that we have to go and make this change, or we are now having to go and look at all our beneficial owners. We need to now stop what we're doing and pay attention to that. The regulatory environment has got so much more complicated. Faye, I see you on. Did you want to add something here? And I'm not seeing any.
Yeah, we don't have any
questions yet.
questions. Well, I can.
There are several comments on the chat.
Oh, yeah.
Oh, let me look at them. Yeah,
Okay.
Camille, you have to be my backup with these comments. Definitely. Okay. I'm looking at the comments
And
now.
Camille, I was actually looking at Danielle's comment, and I was going to add something to which piggybacks on what you just said. You're going to find a lot of countries are going to change. You mentioned that a lot of times there isn't necessarily a definition or specific obligation set out for corporate secretaries. But what we've seen in Barbados, especially, and I know a couple other Caribbean jurisdictions and even other jurisdictions in Europe are doing, is that depending on the type of entity that you provide. So if it's a big company, I think for us now, if your revenue in a particular year is over $1 million Barbados dollars, you are required to have a licensed corporate service provider, which means that you have no excuse. You have no excuse to miss your obligations. And many times, as an in-house corporate secretary, you may not be a lawyer, and that's fine. But then you have an extra added responsibility to ensure that you align yourself with either some other government body or some other private sector organization that provides seminars and updates, because things change so quickly that if you aren't keeping yourself up to date, you will miss things when they change. So I think that that's what we're going to see in the future. I think we're going to see people are going to be required to have a license. The license is going to require you to have ongoing training, especially in the area of AML and regulatory compliance. And that is going to definitely impact and push more towards the corporate secretary evolving into that governance officer role.
Definitely, Sharalee. And Daniel agrees with you, Daniel's comment. That is why corporate secretaries should be continuously trained in different areas such as AML and FATCA, which is exactly the point Sharalee is making. Sometimes corporate secretaries have to demand to be trained. It is difficult to get someone coming into a company with everything from the start. Yes, Daniel, it is difficult. And what we know is we need to have the ability to learn. We need to know when we need the training, and we need to insist on it. And in fact, things are happening so quickly now that we have to ensure we are being continuously exposed. And that is why I have found forums such as these so valuable, because we are hearing from different persons who are operating in different industries. And so I don't have to go and read about what's happening in that industry, because Facey or Debra or Sharalee or Terry came and told us about it here. And then we can know, okay, Terry, please put that link in so we can read that case. So the continuous training is so important. And then Mohini said, we have to demand to be allowed to participate in trainings, not just for our good, but for that of the organization. Correct. And Mohini is agreeing that we don't even know what we don't know. And yes, the link has been shared. Oh, today, the link has been shared, everybody, to our regulations under the PBMA in Jamaica. I really commend them to you. It's groundbreaking. 1/3 of the board has to continue to serve even when administrations change. I mean, there are so many amazing, there are term limits. It is groundbreaking. And in Jamaica now, we just have to fight to maintain them, because of course there was a lot of opposition to it. But there are excellent regulations, and they're going to change the way governance takes place. We're at a point now where we're implementing. Debra, please weigh in.
I noticed there was a comment where I'm not sure who asked the question, where it is that if the matter becomes litigious and
Right.
The company finds itself and the claimant names defendants, whether the general counsel and I would say the corporate secretary is liable. If they're named in their personal capacity, I mean, they can be named in their personal capacity, but if a company is generally sued, the corporate secretary as an officer of the company would be part of that, but they can also be sued in their personal capacity. And because of that, many corporate secretaries or officers ask for an indemnity from the company when they take on the appointment. So if you are taking on the appointment in a personal capacity, and you're not part of a service provider who provides corporate secret services, then the norm would be that you also have a side agreement with the company or an indemnity, whereby if you are sued in your capacity, your personal capacity as the corporate secretary, the company is agreeing or contracting with you to take up that liability, provided that if there is any breach or it's shown that there has been any breach on your part, that you were acting, you weren't acting ultra vires then, you were acting within the scope of authority that you are meant to act as a corporate secretary. So that's just something to be aware of regarding personal liability and how you can cover yourself if you are providing that role.
Yes, thank you for that, Deborah. That is really critical information.
Camille, there's a question earlier in the chat from Alana. So I don't know if Deborah wants to address that as well. She said for Trinidad and Tobago, the articles of incorporation forms the framework for governance. In the absence, do we turn to the Companies Act? I think that is the question she's asking.
Well, in order to incorporate a company, you have to have your articles. What you may not have would be the bylaws. And if you don't have bylaws, then you can revert to the general bylaws under the Companies Act. But in order to actually incorporate, you would have to have articles in Trinidad and Tobago.
In Jamaica too. And you have to have a secretary. You have to have at least one director and a secretary, and they can't be the same.
Well, we have a limit of 3 directors, a minimum, sorry, of two. But it's the bylaws that you don't necessarily. We have companies that come forward now, and when you, and they're mature companies, and when you go and you look, they don't have any bylaws, and they've generally been operating on the basis of general bylaws under the Companies Act, but that's not a very good basis on which to proceed. You should have bylaws.
Okay, that's interesting. If we could just explore that a little bit for those of us who are from a different jurisdiction. So in Jamaica, we have our Companies Act and we have our standard articles of incorporation. We call them, they're Table A. They're on the Table A, usually if you're a private company, or you start with a Table A if you're not limited by guarantee. And most companies tend to adopt Table A. Now, some companies will produce their own articles which vary from Table A, but it is certainly not required, or it's up to you whether you just adopt Table A articles or you produce your own. How does that vary from what happens in Trinidad with these bylaws? And we call them articles of incorporation.
Yes. So generally, the bylaws, exactly what you're saying, our bylaws seem to be similar to what you're calling your articles. You can use, and most companies do use, the standard bylaws, and they adopt it. After you've incorporated a company, you have your organizational minutes. And in those organizational minutes is where you can adopt the bylaws. And most companies would adopt the standard bylaws. But those standard bylaws are generally so general that they will not cover specific scenarios of a company operating in a certain framework. So the general rule is you should read them carefully and make sure that you're not adopting something that is so general that it doesn't even apply to your company. And that's where, looking at it in detail with somebody who has corporate secretarial training and a background will be able to quickly go through it and say, well, this doesn't apply to you. You need to strike this off or don't have it. And we found that even signing authorities, sometimes that's put inside your bylaws and it's not applicable. The titles of who you're giving signing authority to in the general bylaws doesn't apply to a small company being formed in Trinidad. And so therefore you need to change it and make sure it fits in, because otherwise, you really don't have any guidelines at all because you're following something that doesn't relate to your company.
All right, thank you for that, Deborah. And I would say here in Jamaica, or articles of incorporation. So once you incorporate the company, these are your articles. And usually they are applicable. But what I find is that a lot of persons haven't read them. So these are the rules that govern their organization, but they don't even know. And it's the job of the secretary to know those articles inside out to ensure that the company is complying and to guide your directors. I see Danielle saying, excellent, thank you, Debra. Yes, thank you there. Any other questions? Kamala, have we missed any questions?
No, that is it so far. But I want to ask if anyone wants to speak directly to what is the difference now if you what is the difference between liability for the corporate secretary versus the liability of the general counsel? Because I know that issue was raised in the earlier panel where someone made the point of privilege when you were the general counsel.
Good question. Does anybody wish to take that?
Can go first. I think it depends on the individual that sits in the role. If you have someone that plays that dual role of both general counsel and corporate secretary, it's going to be difficult to distinguish where your liability as corporate secretary starts and ends and where that of general counsel starts and ends, because you're going to be going back and forth between those two. But when you have two separate persons, I think it is easier to pin down the liability. Again, we remember the liability of the corporate secretary is to the company. And a lot of times, because it's a fiduciary duty, it's a statutory duty, it's going to be more clear what your liability is. Whereas with an attorney, general counsel, your liability is based on the engagement. So you may be general counsel, but your role as general counsel is restricted to certain things. You may then have to engage external counsel for certain things, so it just depends on, in my view, it depends on what you are doing in the particular circumstance. You may not have the same privilege, because your role as general counsel may not necessarily be the same role as a litigation counsel, right? So I think it depends on what you are doing. It depends on what your engagement entails, and the laws in your jurisdiction. Does it cover every single attorney? In Barbados, our privilege depends on the advice that you give. Is it something that you're giving as counsel for a particular matter, or is it just advice you're giving as part of management, right? So that I would say that the general counsel liability is a little trickier, especially when you're in-house counsel.
Okay, thank you for that, Sharalee. Debra, do you want to weigh in on that?
I do agree it's difficult to divorce if you're acting in the dual role. And I do think the role of general counsel can sometimes involve that deeper legal advice from a commercial perspective. And therefore it really does make it a little more difficult to divorce the two roles. And it comes back to, I would say, just getting that indemnity, and also in giving advice, as we heard earlier on today, that you may have done before, Camille, say, I am giving this advice in my capacity as X. I'm giving you legal advice in a commercial capacity then. Because sometimes when you're sitting in these meetings of a board, they're just asking you for your advice, but they're not understanding you could be playing two separate roles. And I think it is important to try and make a distinction when you are giving advice. But at the time of liability side of things, it's very difficult to divorce it and say, no, I was giving it in this capacity and not that capacity. I think it's very difficult if one person is playing that role.
Definitely. I think so too. I think so too. And things have got even more complicated now for large organizations where you also now have responsibilities for your subsidiaries. So the whole matter now of subsidiary governance, and we have seen cases where the subsidiary activities done by their boards have caused the parents to have issues. So the whole governance area has just it has so evolved and got so much more complicated over the years. I don't know if anybody has anything they would want to add in terms of the whole
so I
situation
want
with
to
the
add,
subsidiaries.
Camille,
Mhm.
that some of the previous sessions that we have had, particularly the one significant court judgments that Faye and Allison had conducted, that look at that, the Saffron, was it, Faye? The Saffron case out of Australia. I was just checking to see if Sharon was still with us from Dubai. She was the one who brought it to Allison's attention initially. But that case really helped demonstrate just what a thin line it is, you know, for corporate secretaries, because the court in that Australian case was holding the corporate secretary to a very high standard. And so we have to look at that space in terms of how it's evolving, because it means that if it is that you are expected to provide a certain level of guidance in the boardroom, the court is not as easy going to separate and say, well, that wasn't your position. In that particular case, it was that the court said, you are acting as corporate secretary and you had specific knowledge about this sector, and therefore you had an absolute responsibility to ensure that the board was aware of the danger, you know, of the decisions that they were making. And I think that really brought to bear for us the point of how important it is that we look at how the space is evolving.
Yes, definitely, Kamala. I agree with that. Okay, well, we don't seem to have any more questions in the space, ladies and gents. I think you have answered the question that was put to us this morning very comprehensively.
So
what
let
is the
me ask
liability
a
of
question,
the
Camille. Now that we understand the extent
liability?
of the liability, we have a lot of persons who are corporate secretaries here. How many persons would say, had I known this before, this would not have been the area that I choose? Because as you started this panel discussion today, you really demonstrated how the role has evolved, especially from a legal perspective, in terms of how the position is viewed and what is expected of the individual. Apart from the functions that you perform, there's greater clarity in terms of your liability, in terms of fines and costs, and possible prison time, as Debra shared in her contribution with respect to the Beneficial Ownership Act. You know, there's also the Non-for-Profit Act and the importance of compliance to these things. So is there any corporate secretary who is present now who would say, nah, I should have been a mathematician?
I certainly think that the more we talk about it, the more I become convinced that the two roles need to be separated, because there is so much focus that the corporate secretary now has to give to the responsibilities and the duties that are unfolding even as we speak. And when you think of that legal role and the ensuring that you are reviewing this contract, this major contract, and that all the terms are covered, or handling the litigation, or whatever it is you are doing as general counsel, to do both things, really, what you'd have to end up being is really just the manager on top, who is ensuring that you have a strong secretariat and that you have a strong legal team, because the span is wide. Daniel has her hand up.
Yes.
Daniel, please weigh in.
I just want to say, first of all, that, this has been, a very insightful forum. For me, I, sit as corporate secretary in, a small bank. It's not a very big commercial bank. But, hearing everyone weighing in terms of the responsibilities, it just dawned on me because I'm thinking, okay, if, I have to sit eventually or change into or morph into a CorpSec / general counsel, how, and somebody, you're sitting with HR, I'm being very practical here, you're sitting with HR and they hand you a job description and you have these, these responsibilities outlined in the JD, but of course they can't put, you don't ever get everything in a JD, right? How do you know whether this is something that you can handle, realistically speaking? Because me listening to you now, I'll be like, okay, I'll be looking for certain things in the JD. I may not see everything in the JD, but I know, or I'm more aware of the implications of the dual roles. So that's one thing. The second thing that I was thinking from since early this morning is, and I think Camille, you raised the point just now, where I see general counsel not going into the nitty-gritty of legal work per se, but I think it just does depend on the organization you're in. If there's a legal unit and a strong legal unit with a legal manager heading that unit, would it be better for the CS/GC to lean on or to sort of have that umbrella sort of supervisory position or role and rely on the legal unit to do its, to attend to the nitty-gritty legal matters, and then you have the corporate secretariat to deal with the corporate governance matters. I'm just wondering where do you draw the line in terms of how deep or how much you delve into the particular roles? I don't know if that's clear.
Yes, I'm understanding what you're saying. And so somebody is advising that we are to call Faye for second opinions if we need any second opinions on any of these things. And I will just weigh in, having done that joint role, that you also have to remember that you have to put in that managerial role as well. Because if you have a team of people, you are responsible for that team. You are responsible for their development. You are responsible for their supervision. You are responsible to ensure you keep building that good, strong team. And management takes time if you do it properly. So here it is, you're doing the corporate secretary role, you're being legal counsel, and you are management as well, and you are managing the team, and you are a part of the senior management team, trying to ensure that the company meets its objectives.
So in essence, you're playing three roles, really.
You're playing multiple roles.
Multiple roles, yes.
And how many masters can we truly serve at the same time? Something is going, we are physical beings, and you are going to prioritize one over the other. And I have found in my time as a director that very often the corporate secretary prioritizes the legal work as she has to if she's going to court or whatever. And then the support that the board needs is not as well delivered as it ought to be. And as a director, I have a difficulty with that because I know the responsibilities of the director. Debra, please weigh in here.
Yes, I just wanted to endorse what Camille is saying there. Now, there are two levels that we're talking about. One is somebody who's working in a company, in a corporation, who is the general counsel and corporate secretary. And then you can take it a layer higher or further, where it's a provider, for example. I sit at Hammersmith & Company, and I handle a very heavy litigation portfolio, and I'm the partner who sees about the corporate secretarial. And it is very, very difficult. What I find myself doing is I do litigation during the day, and then when everybody leaves to go home at 6 o'clock, then I start my corporate secretarial. So I'm in my office feeling as though I'm doing two jobs, because you need to pay attention, but it's two completely different skill sets that you're using. And it's two jobs. It's not one job. So they are, you know, and I have a team under me in the corporate secretarial side of things. But as Camille is saying, yes, you're managing your team, but you're also managing the nitty gritty. You know, have we started, for example, in order to comply? This is your end point, but you have to start long before. So you have to set up, I mean, a schedule basically for each company of, okay, so this is the compliance deadlines. Because we have all of these obligations, you can't start on your filing date and use your filing date as the date that you're trying to work towards. You have to say, well, okay, if I have to file on that date, I have an ultimate beneficial owner who's in Switzerland, and there's a time difference, and I have timelines in which I have to comply, because the Act says when I send my notice, just to get a little specific here, just when I send my notice out, I need to get my declarations in from my UBOs within 30 days of that notice. And then within 30 days of that, I need to file my first return. And then within 30 days of that, I could. So there's a whole scheduling of compliance. And if you miss any one of those filings, you're exposing. So when you layer that onto now several companies, not just one, and then you layer onto that several other obligations in terms of the shareholders and getting in touch with them, and during COVID, can they get to a notary public? Can they get the documentation back to? Is it a wet ink signature you need? Is it? There are a lot of obligations, and the corporate secretary is the one who would, you're dealing with the legal aspect, the administrative, the regulatory. When you switch now and you're in deep litigation, many times the heavy litigation is bet the company litigation. So you bet your bottom dollar. And a judge doesn't want to hear about you have some filing in some registry to see about. So it's two jobs, two full-time jobs. And some of us are silly enough to say, well, yes, we'll take on this role, you know, and then, you know, you left your child at the side of the road because you forgot to pick them up, because you said, oh, shucks, I just remembered I have a child to pick up. So
your child who will never forgive you, and your child in respect of whom you are the only mother, because that's the other thing that we have to balance. But Deborah, you are completely right. Those are the sorts of issues and things we have to think about.
And related to that, Camille, what was going through my mind as we spoke was, so how do we ensure that directors are now fully cognizant of what the corporate secretaries need to deal with, so that there is that balance in the boardroom as well? Because if directors are not as aware, then there may be some unrealistic expectations. And maybe to an extent that has contributed to the role growing as onerous as it has. Because very often directors think, well, that's a corporate secretary's role, that's a corporate secretary's function, and doesn't have a full appreciation of what it means for the corporate secretary in terms of being able to fulfill all these functions, as Debra just very clearly outlined to us. And second to that, the liability that will now obtain on the corporate secretary if they're not able to fulfill it properly. That's first to think about as we figure out how we ensure that directors do now begin to get that message.
Right. And I think directors training is so critical. And certainly in Jamaica, we have a corporate governance index where one of the things we measure is whether or not the directors have had training, both in public sector and the private sector. And in training, as we share with directors that this is a new law, this is a new responsibility, this is a new requirement, it becomes evident the extent and the breadth of the work. So corporate secretaries, yes, you have the corporate secretary, but she has a team below her that helps her. And as I say, and Debra just reinforced my journey to that road where I believe the things do need to be separated. I mean, in the past, when I started out many years ago, it was okay, it was a happy marriage. but the role has so evolved. Am I putting myself in jeopardy? Am I putting the company in jeopardy if I continue to try to straddle the two? I no longer do, but I'm talking about the persons who do straddle those roles. And so each of us has to look at our own situation. But what we have agreed this morning is that there are liabilities. The liabilities are growing. There are things called derivative actions that we never used to see in the Caribbean, but are now coming up. There are many issues, and I'm going to read Sharon before I just ask our members to close off. You know, I'm working and listening at the same time, she says. A key point was just made relating to work-life balance. Yes, I'm telling you about it. I have 3 children, or they've grown now. The job of company secretary is already so full that to take on general counsel as well, we may lead to burnout, especially for those of us that have families. And I still have a grown child who remembers the 1 year when he was 10, when I had to travel and came back the day after his birthday with lots of presents. But to this day in his 30s, he remembers I was not here for that birthday. So it is real for us. Terry, are you a dad? Is that something that you have had a challenge with in terms of the work-life balance that so many of us women talk about?
Yes, I'm a dad. I'm a proud father of a daughter and a son. And I work as my full-time job as a corporate banker with CIBC First Caribbean Bank, as well as holding all the responsibilities as, you know, in various capacities as a consultant and so on. So this is very important. Work-life balance is definitely important. So I try to make up for it over the weekends and during vacation times. And one thing I wanted to say before was that when I look at my part of the Caribbean, the courts really depend on what they see in the articles of incorporation. While you may have in the other jurisdictions, you have the blanket Company Act and so on, the court usually leans towards what is in the articles of incorporation in the Dutch Caribbean. And so you would see that some companies have an inside counsel or an external counsel, or you may have one having a department with a compliance officer or an in-house officer. I remember in one case in Curacao called the Aqualectra case, where you had the judge deferring a certain case by the company that needs to take action in terms of the liability incurred. The courts are not so much interested in going after corporate secretaries and corporate officers. You would see them moving in the direction. If the prosecutor has the case, they would go after the CEO and the directors and so on. So in that sense, I would say corporate secretaries should not be too frightened to take up the role because of course we start to panic. I'm sure there are persons who are corporate secretaries and now panicking, oh God, do I have an insurance? Must I get an insurance to save myself from liability? There are other things happening with companies in terms of amending the structure of their companies, amending the articles of incorporations to ensure that they protect. And as part of the work-life balance, there must also be protection of staff as well as the employees of a company.
Right. Thank you, Terry. And I think the answer is not to be frightened, but to ensure that you are knowledgeable and to put in place systems that ensure that things are done and done well. And we have Gail guiding us here, Gail Alec. I prefer to think of it as work-life harmony, lovely term. I have realized that balance suggests equality, and the reality is that at different times, one will take priority over the other. What I strive for is to ensure whichever aspect of my life may be in play at any time is getting the best I can give. Very wise words. Though I will say sometimes it's easier said than done. I remember going into a really important meeting, and I'm about to go into the meeting and the school is calling me to tell me that somehow my son has just managed to sit in dog do and I needed to come for him immediately. And I'm about to go into this meeting and I said my very competent section. I couldn't reach my husband, who is usually on standby, and I sent my very competent second because I was going to school for my child because he was totally embarrassed and I was not leaving him there. So those are the real issues that we face. Sharalee, do you want to give us your final words before we ask Debra to give us our closing words? We just heard from Terry.
Yeah, I would say that I think we have to take, a lot of what we learned coming out of COVID-19 and, people reflecting on your mental health. And I think we, as attorneys, especially when you play that joint role, we believe that we can get it done because we're so used to doing it, but we don't need to get everything done. And I think sometimes we need to be honest with ourselves and realize that sometimes you can't do a good job if you don't take rest. Sometimes you have to have that level of communication and respect with your management to let them know I have a completing liability, I have a completing obligation, and this is a priority right now, and I can't do all three of these, and I think that's what we're going to have to move to, because the reality is that the role is bigger than the individuals who are in it. And I think we have to manage expectations. And I think a big part of us, being able to get that work-life harmony is about managing expectations, being assertive and, giving clear expectations of what capacity you can and cannot, take on at the moment. And I think, it may seem as though you're trying to, take too much back from the job, but unless you are in the right place mentally, you're not going to be doing the best job. You're going to be rushing through work. You're not going to be giving attention to detail. And with the roles that we have and that we play as corporate secretaries, and in many cases joint role with general counsel, detail matters. And if you aren't taking that time to, to reflect and to recharge, you're always going to be chasing a never-ending finish line. So that's what I am trying to take into my role, and not being afraid to ask for help. I sometimes don't do that as well as I should, and my colleagues are fantastic and they always reach out and say, what do you need me to help you with? But sometimes we have to be willing as well to ask for help.
Very wise words, Miss Sharalee. Debra, what would you
just to add on to what Sharalee has said in a winding up, I think the bottom takeaway from this should be, don't be afraid. Face this head on. Yes, there is an expanding role and there is expanding liability. But the key for me, the key takeaways are: be aware of what the liability is, educate your boards, educate your directors and let them know what that expanding role is. Put as many systems in place as you can to ensure that you can comply. And last but not least, if you do need a larger team to help with it, say that you need it and express why. Bring those liabilities to the forefront of your board, because the board will be looking at the bottom line, no doubt, and express why a company would need to have more than you dealing with the whole corporate secretarial side of things. That would be my takeaway on this.
Debra, that was brilliant. And I don't know if you all realize that Debra just told us what is best. Be aware of the liabilities. E, educate your board. S, systems must be put in place. And T, have a good team. That is best. Ladies and gentlemen, I think we have had a very engaging discussion, a very deep discussion where it's been wide-ranging, but that's kind of how life is. So at this point in time, unless there are any other questions or any other panelists want to say anything else, I am going to say thank you so very much to each and every one of the brilliant panel. Let me see, give me the claps. I want to see the claps for Terry, Debra, and Sharalee. Thank you so much for taking the time today. And with that, I'm going to hand back to Camilla.
Yes, thank you very much, Camille. This really, really was such a great panel as well. And I want to tell you, it really helped bring home for me too, the fact that I really need to stop trying to be superwoman. Ensure that I get that balance that we spoke about. So Sharalee, I thought your summary in particular applied to me. So rest is very important, and to be able to manage some of what we take on, because you are quite right. The role is so much bigger than us, and we need to make sure that we manage it in such a way that we don't end up doing damage instead. So I really, really, truly enjoyed this panel, and I felt I learned so very much. So thank you guys so much. As we bring this together and we prepare for what would be our third and final panel for today, we will be going to our half-hour break to give everyone a chance to be able to stretch their legs, you know, have a quick bathroom break. Those of you who where it's now heading to lunchtime, you may want to have a quick bite or so before we come back to be able to engage. I want to share that we will have one change in our panelists for this last session. So when we return from the break, we'd be looking at the panel discussion entitled Moving Forward, the Corporate Secretary as the Chief Governance Officer. And we have our moderator will be Francis Bain Cumberbatch. And I think Francis is already on. So Francis, I'm letting you know in the 15 minutes before we start back, that's when we are going to do some technical checks and so to make sure we have good audio and video with everyone. And Francis will be moderating a panel that includes Elsabe Kirsten from South Africa, Katrina Baptiste Assi from here in Trinidad and Tobago. And our change is coming from Brazil. We did have Adrienne de Almeida, who initially was going to be on the panel, but Adrienne has advised us that she's not able to make it, but she has her colleague who has very, very generously agreed to step in at the last minute to ensure we continue to have a contribution from Brazil. And I hope I'm pronouncing his name correctly. I'm thinking it's Terrio. So if it's not Terrio, forgive me. We would get that correct pronunciation from you as you come in, or one of your colleague. So we would be returning to now look at, we have covered already, you know, the dual role and how it's held, and that was what was delivered by our opening keynote this morning, who holds that dual role at Boeing India. Then we discussed the whole notion of should the roles be separated, and now we have very, very detailed examination of the liability for the corporate secretary and how onerous that role is growing as things evolve in the governance space. So now we are going to continue with our final panel when we return with whether it should now be a chief governance officer, which clearly demarcates the two roles. All right, so thank you all very much. For those of you who have just joined us, as we go on the short break, the room will remain open, so you can stay connected. Christy, I want to ask you if you could put the agenda back onto the chat as well, so new persons would be able to get it, as some of these persons would not have received our link this morning where the agenda was sent out. So just to make sure that everyone has the agenda, so you have the full profiles and bios of all of our participants. And in fact, what I will do is I would also put up the information from our new panelist from Brazil in the chat as well, so everyone will have detailed information for him. All right, so it's now 11:32. we go on a half-hour break and we resume with the panel formally at the top of the hour. Just before that, of course, as I mentioned, I'll come back and we'll make sure that we have our technical tests for everyone. Thank you all very much.